Thank you. Be seated. Good morning. Now is the time for oral argument in cause number CACR 180708, State of Arizona versus Frank G. Is it Kitko? Thank you. Junior. For everybody's information, the proceedings continue to be audio and video recorded and live streamed. As you all are aware, I'm sure they will be available and you can critique yourself in a week or so, I guess. Counsel, each side will be entitled to 20 minutes, the standard amount of time that's allotted in this court. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all your time if that's possible. However, ultimately, reserving rebuttal time will be up to you. We've reviewed the briefs. We have conferenced this case this morning, so we are well aware of the facts and the issues attendant to this argument. You might want to keep that in mind in figuring out how you want to use your time. When you come to the podium, I would ask that you state your name and who you represent. And with that, appellant's counsel, it's yours.
May it please the court. My name is Katya Mayhew, and I represent Mr. Frank Kitko. On behalf of Mr. Kitko, I ask the court to vacate his convictions and to remand the matter for a new trial. I reserve 2 minutes for rebuttal. Now, in our reply brief, we addressed an issue having to do with the government's request for finding a procedural default. Obviously, that's a secondary issue. We're here primarily on the jury selection claim. So I would like to jump right into that if I could. Every person who takes his case to trial is entitled to a whole gamut of constitutional protections. When Mr. Kitko took his case to trial, at the point where he was trying to choose a jury that was going to be fair and impartial, he had a number of constitutional protections due to him. So the first one, as we all know, is the constitutional right to be tried by a fair and impartial jury. To get there, we have a 14th Amendment right to a fair procedure, which is due process. We use the word due process as a shortcut, but it basically means, as I've said, that every person is entitled to due process of law before the government, and by that I mean both the prosecution and the court, takes away the person's life, liberty, or property. Mr. Kitko was not accorded that fair procedure here. And I think if you read our brief, the opening brief in particular, because we went into great detail as to what occurred during the proceedings. And as you can see from the very beginning, the trial court realized that things were out of control. The trial court itself says, this is going downhill. This became a free-for-all. And I don't know what it is about the medical boot that really got on people's last nerves. I'm not sure what caused them to be so concerned about it, but they started to express their views about the boot, about the fact that they had the boot at one time, and the doctor says don't wear a boot. My mother wore a boot. They told him not to wear a boot, and what was happening is that.
But none of those jurors were on the panel. None of those potential jurors were actually on the panel that decided the case.
Yes.
Correct?
Yes. No. I'm sorry. That's incorrect. Panelist number 51, who responded to the court's questions, do you feel that Mr. Kitko is guilty at this point? He was impaneled as juror number 11 and rendered a verdict.
And
51.
did you move to strike him for cause?
Well, I believe that trial counsel did everything he could to get the court to basically just start over, because what was happening
Now,
is
I
that,
know the question of the panel at large. As to that juror that you're asserting made the jury and said something inappropriate below, was he moved to strike? Was there a motion to strike him for cause?
I believe there was. I would have to double check that. I did double check that he was impaneled as juror number 11
And
and
counsel,
served until the end.
I'm sorry. These people were responding based on their own understanding, right? Their own knowledge. Isn't that what we do in the course of voir dire? Don't we invite people to comment about things that may put them in a position that there's someone that can't serve on the panel?
Right.
And so these people were talking about, they either had family members or in their own personal cases, they'd worn the boots, they'd been told not to wear them and drive by the doctor. So they were really doing the thing that we ask jurors to do in the course of voir dire.
But not to the point where, but at the point that so many of them were expressing these perceptions. And I believe one even said that Mr. Kitko was probably guilty. That's that's crossing the line, because basically what's at issue.
And they were removed.
I'm sorry, Your
And
Honor.
they were removed. The guy who said they're probably guilty, he's removed. He was taken off the panel, right?
Well, that's not the answer to, that's not what determines the fact that the error occurred here, because Mr. Kitko was prejudiced by the voir dire.
Isn't the burden on you to show that a specific juror was prejudiced by those statements? One of the jurors who was actually on the panel, and I don't read anything in the record that shows where one of the jurors who actually decided the case said or implied or anything that the statements of the other jurors affected his verdict. Otherwise, we're just engaging in speculation that they might have, which the Supreme Court has told us we should not do.
Well, that's not exactly how trial unfolded. If you recall, from the very beginning, the prosecutor's opening statement focused on the medical boot.
Mm-hmm.
The very first jury question was about the medical
Right, but
boot.
your claim that you're arguing now is that the panel was so tainted by the statements of the jurors that were ultimately excluded.
Correct.
But I read Doerr, D-O-E-R-R, I believe it is, the case is saying we can't speculate about whether individual jurors that actually decided the case were tainted. We have to have actual evidence that they were tainted. So what is your evidence that juror A, who actually made it on the panel, was tainted by something that juror C said during voir dire? Well,
We have to take a step back. We're actually talking about the fact that that there was a material departure from the requirements of law during the jury selection itself.
What was the material departure from the requirements of law?
The number of jurors who basically expressed their opinions, and the fact that the trial court could not get the jurors to stop talking about it. That's what the 14th
I think
Amendment.
the trial court did. He stopped and engaged in extensive colloquy where he explained the burden, the presumption of innocence, the burden of proof, explained that there was no, if I recall correctly, there was no law against driving with a boot, and that there would ultimately be proof need to be adduced is that he was even wearing the boot. So what is your suggestion that there was some breakdown in where is the evidence that there was a breakdown in the requirements for voir dire?
The evidence was present in the trial court statements. The evidence was present in the number of jurors who basically made this, who basically view the fact that there was a medical boot as the make and break it in this case. Because what happens when we're talking about recklessness, what that comes down to is you have to prove that the person was aware of the risk and consciously disregarded the risk. When everyone is sitting around talking about this boot, and the trial court was unable to bring the jury back to a position of neutrality, then Mr. Kitko's rights were infringed.
What in a situation like this, you may not have thought of this because this is not your perspective or your or your client's role, but what is a trial judge to do when boom, 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 you get all these comments coming out from the panel?
Your Honor, the trial court has a duty to ensure that the proceedings comply with due process.
Right,
He's
but
entitled to a fair procedure. What the trial court, what the defense attorney did was offer the trial court a way to deal with it. Let's strike this panel and start over.
I mean, what should have happened an hour before? Is it your contention that the trial judge should have said, wait, everyone who's raised your hand about a boot, we need to talk to you individually? Is that what the judge should have done, or what do you think?
Well, that is another option. If the trial court felt that it wasn't appropriate to strike the whole panel and start over, the other option available to him is to do individual voir dire, and that did not occur here. And the problem is that I think so many times we forget that the jury is there because the jury is supposed to be a way to safeguard a person against the arbitrary exercise of power by the prosecutor of the judge. So when you allow the jury to just get caught up in itself, you basically remove that barrier of due protection due to a person who's being accused. So the fact that this went on for so long, that's where trial counsel said, Judge, and I believe trial counsel raised this issue 3 separate times because he saw it.
What about that? That may be your argument may apply in other situations, but here wasn't there didn't one of the officers testify that after the accident at the scene, your client said, I shouldn't have been wearing the boot? Did that evidence come in? I'm sorry, I shouldn't have been driving while wearing the boot.
Right, but he also should not have been drinking alcohol or taking fentanyl. That didn't come in. That wasn't emphasized as much as the fact that he was wearing a boot. So that's where the fact that the boot took on such an incredible what's that word? The jury found it to be really, really prejudicial that Mr. Kitko was wearing a boot, but he had also had a few drinks. Why wasn't that emphasized? Why was this the greater, I guess, sin for the jurors as opposed to everything else that was occurring? And that's why, Your Honor, and that's why the fact that the boot was such, that's why, because the fact that the boot became such a overarching point for everyone involved, that's where Mr. Kitko was deprived of due process.
Counsel, is that then to say that the first time that a juror on the panel says, my doctor told me it's dangerous to wear this boot and drive, does that then contaminate the whole pool?
Of course not.
Okay, 2 people say, my doctor told me not to wear the boot because it's dangerous to drive. Is that when you prejudice?
Absolutely, Your
2
Honor.
people and we have to get a new panel?
In this case, absolutely, because it didn't stop at 2 people. And the judge himself says this is going downhill. Because I don't know what it was about the boot or the makeup of this particular group of people, but for them, not everyone, a number of them had a number of stories about people with medical boot. Why wasn't there a number of stories about people drinking and driving? Why did that become the one reason that they were going to hold that Mr. Kitko was probably guilty of committing aggravated assault?
Yeah, I guess that's not my question to answer.
Well, in terms of that, Right, actually, I guess it is, the court does sit, as an appellate court, so it will have to determine whether the lower court applied the law incorrectly.
But counsel, the problem I'm running into is a juror says, I own a gun. And there are people on the juries on the balance of the jury that have issues with that, right? I mean, people seem to have pretty, what do you want to call them, strongly held opinions in regard to whether people should own guns or people should not own guns. So as soon as someone says, well, I have a gun and for some reason my experience is X in the course of voir dire, should we then say that because that raises an issue that is a driving force in a lot of people's lives, for or against, that we then should just clear the panel out?
But Your Honor, we're talking about almost two separate things here.
Go
We're
for it.
talking about bias and due process. Mr.
And that's
Kitko,
different than my gun example.
yes, because your gun example goes towards the bias issue. So first we're at the point where Mr. Kitko was not accorded a fair procedure. And then we get to the point where Mr. Kitko could determine for himself that some of the jurors were biased and some were not.
I'm having trouble following something. What exactly is the fair procedure he was denied?
The fair procedure he was denied was a procedure where the jurors were kind of reined in at the point where it became a free fall.
No, but what is the procedure? Because we have various procedures. One is trial by jury, so he was afforded right to a trial by jury. He was afforded the right to jury selection and to question jurors and have voir dire. What is the procedure? Is it the procedure in saying once there's a statement from a juror that may contaminate other jurors, that per se just makes the whole panel good, and so it violated his procedure to voir dire to proceed with that?
Well, when I'm saying it's per se, Your Honor, we are saying that the number of jurors who basically expressed the opinion made it into did not accord him due process, because the trial attorney was aware enough to say, Judge, this is, the well has been poisoned here. Let's step back and get and get some new people to basically consider this issue. That's where the due process might accorded.
What's our standard of review? I mean, it seems like, so the decision that you're challenging is the court's decision not to strike the panel and provide a new one. So it seems like, I'm not trying to put words in your mouth, but it seems like you also acknowledge that there's some point at which you cross that threshold. It's not a numerical thing. It's not just one or two, but at some point that's enough.
It's de novo review.
It's de novo. How can that be de novo?
Because we're raising a constitutional issue.
No, that's not right. There has to be, it's a constitutional issue. Yes, we defied what the Constitution provides de novo, but there has to be some discretionary review of what the trial court's decided. The trial court has to be able to decide, this is a level at which the taint has become too much, right? To raise that constitutional issue. Because if it's just one, you said it's not a problem, so it's got to be, we have to defer to the trial court's decision on when it actually becomes a problem.
Well, I'm not sure about that, because this court has to determine whether the lower court applied the law correctly. So I'm not sure about I'm not sure where you are going to draw the line exactly here.
Well, let me ask you this based on, I'm sorry, go ahead and finish, Judge.
No, I'm finished, thank you.
Well, what I was going to say was, that's okay to say, but what you got here is a situation where the judge removed all the jurors who might purportedly be said to have stated a bias or expressed a bias.
Right, but we still have the
And that wouldn't,
prejudice
wait a minute,
prong.
but to draw the thread on this, but that isn't good enough. There's
Right.
something that has to be done more. Do we reserve maybe people who nod while he's speaking? You understand what I'm saying? They're in agreement with him maybe, or they're not in agreement with him maybe. How do we then go to the balance of the panel who has not said anything about having a bias or indicated a bias and say, okay, you're out of here? How do we do that?
By striking the panel, Your Honor.
Whole panel, every time.
And
When we
yes,
When we
that's,
get to two people who express an opinion that's the same.
no, Your Honor, just what happened in this case. This is a fact-specific analysis. I still have 1 minute and 53 seconds I would like to hold them. Thank you.
All right, thank you.
Good morning, and may it please the court, Michelle Hogan with the Attorney General's Office representing the state. This court should affirm Kitko's convictions because he has not met his burden of demonstrating that any seated juror was actually prejudiced or biased against him. Instead, he asked this court to disregard the seated jurors' avowals that they could render a fair and impartial verdict and assume prejudice. But nothing in the record indicates that any juror that was seated had any preconceived notion of his guilt or could not decide the case fairly and impartially.
Counsel, is there anything in the record or any reason to believe that the court was aware that the boot issue was going to take off the way this one did? Should they have gone into this saying, oh, look, we know we're going to have a problem here, and handle it different?
The discussion about medical boots seemed to be spontaneous after the trial court described the allegations against Kitko and asked if any jurors had some similar experience in their background. And I believe one of the jurors started with, I wore a medical boot and I had been advised not to drive. And that's where the discussion began. Another juror also had a similar experience. And then defense counsel, the state, and the trial judge went off the record and had discussion. And then they continued with voir dire and asked if any other jurors had similar experiences.
So hindsight's 20/20, right? If
Right.
that's the case, what should they have done?
Here, the trial court took steps to assess the impact of those prospective jurors' comments on the entire panel. So after the medical boot discussion, the trial court immediately explained the presumption of innocence and the burden of proof, and further explained that disregarding medical advice doesn't necessarily meet the definition of recklessness, and that the jurors would have to decide the case based on the evidence presented at trial. So the trial court took remedial steps to assure that the other jurors or the panel wasn't tainted by the comments of several.
I'm curious about our standard of review. Would you talk to us about that?
I understood the objection to be below to be under Arizona Rule Criminal Procedure 18.4 to motion to strike the entire panel, not a constitutional objection. So it would be abuse of discretion reviewing the trial court's decision to deny that motion.
But the basis, let's assume the basis for the motion to strike is a constitutional one. This veneer is not fair, and there's no way you can pick 8 or 9 or 10 or 12 people from this veneer and be fair. What's the standard of review then?
Well, it's difficult. I would guess that they raised the Sixth Amendment claim in their opening brief, essentially that they were denied a fair and impartial jury. And generally, constitutional claims are reviewed de novo. But again, they didn't raise that below, and they didn't really preserve it in their opening brief.
But if they did, then what would be the standard of review?
There would still have to be deference to the trial court because the trial judge was there to assess the jurors' facial expressions, their body language, and there's more in the record that you can't proceed, or I'm sorry, there's on a cold record, it'd be difficult to assess the taint of the entire panel.
Is there a similar circumstance of a constitutional argument, a due process argument that relies on facts, on what actually happened in the courtroom that might be in the particular purview of the trial court?
You know, I couldn't find a particular case that was similar to this where there was a constitutional claim. It's generally a motion for a mistrial or a motion to strike the entire panel, and obviously that's abuse of discretion. I couldn't find a case that was a constitutional objection at the trial court. And
Well, on Batson challenges, for example, that's a constitutional issue, but we defer to the trial court's finding of fact with respect to the bias or the reasons given as to whether a cause or a strike is pretextual or not. Wouldn't that seem to carry the water here?
yes, just looking at the facts and deferring to
So we
their
defer to the
fact-finding.
trial court's decision as to whether the reason is pretextual or not within, it's not a absolute deference, but we look at whether the trial, we acknowledge that the trial court's in the best position to judge that. It seems like this is very analogous, even on a constitutional issue, that the trial court would be in the best position to figure out how badly the jury has been tainted and whether there's actually any taint on the jurors who are seated. Would you agree with that?
I would agree that there should be deference to the trial court's fact finding that they hadn't demonstrated that the entire panel was tainted.
So it's a de novo review if you have a constitutional, a finding that there was a tainted jury, for sure. But we have to have some facts in order to understand whether we've reached a Sixth Amendment issue, it seems to me.
Yes, yes, in this case, when you're.
Wouldn't you agree, now moving on a little bit, wouldn't you agree this is, there was a cascade effect here, that there was such a bam, bam, bam situation going on, that this kind of takes it out of the normal cases where you have one off or two off comments?
Yes, there were a number of jurors that had either, I mean, not all of them had received medical advice not to wear a boot while driving, but a number of jurors just had experience wearing a medical boot.
And there were quite a few jurors, if I remember correctly, who said, well, he's guilty if he was wearing his boot while he was driving, or something to that effect.
There was
Or not jurors, I should say, veneer members.
There was at least one prospective juror that was shocked by the defendant wearing a medical boot and said something to the effect of, you shouldn't be doing that while driving, and I can't decide this case fairly and impartially now.
Was he removed or he or she removed?
Yes. Well, every single juror that had experience wearing medical boots was removed
My point.
by mutual agreement. And anyone that had received medical advice similarly was removed and was not seated as a juror.
Talk a little bit about, because I thought defense counsel made a good point on, it does seem that this was the kind of the crucial point of the state's case, the medical boot. And could you respond to that?
Well, I do believe that this court should limit its review to voir dire, not what happened after the fact, because we are the use of discretion. And there's no evidence that the state changed its theory based on what happened at voir dire. It was part of the state's theory from the beginning that they could prove recklessness based on the defendant's wearing of a medical boot. But all the evidence at trial shouldn't be part of this court's analysis on whether the entire jury panel is tainted.
Why is that?
Well, because at the time the trial court was making its decision, it didn't have the entire trial record before it. So it had the evidence of that the remaining panel members could render a fair and impartial decision. And it shouldn't change the analysis of abuse of discretion based on the evidence at trial.
Although the converse of that is a prosecutor and acting in bad faith could take a comment, an unrelated comment in another case, made by a juror who ends up being seated, and take that notion and change his theory at trial to feed into that, right?
It's possible, but here, when the trial court explained the case to the jury, it was that the defendant drove while drinking, taking fentanyl, and while wearing medical boots. So it was part of the state's theory from the beginning.
The overall theory.
Right.
How does this differ from the issue a number of years ago when my hair still had some dark in it? How does this change from questions asked of the veneer and DUI cases? How many of you have either had DUI issues in your past or had people in your family with DUI? You with me?
Yes, I understand.
How does this differ from that? And I don't know, maybe they're not doing that anymore. But it certainly seemed to be the central question when I was at that point. What's your comment?
To me, it's not. Jurors are going to have strong opinions about drinking and driving or any number of issues that come up in state's allegations. And as long as the trial court assesses that the comments about drinking and driving or here about wearing a medical boot didn't have an impact on the seated jurors, that's sufficient and he cannot establish prejudice. And these comments were far less egregious than in other cases where the court has upheld a trial court's denial to strike the entire panel. For example, in State v. Dorr, one of the prospective jurors stated that he worked in a prison and had only known 3 people to be not guilty. And that wasn't sufficient to show that the entire panel was prejudiced because the remaining seated jurors said that they could decide the case fairly and impartially and based on the evidence presented at trial. And in State v. Lujan, a prospective juror who was basically an expert in gangs, he worked on a violent gang task force, stated in front of the entire panel that he believed the defendant was a gang member based on the way he dressed and his hairstyle. Again, that wasn't sufficient to show that the entire panel was prejudiced. He also said, this prospective juror stated he would believe law enforcement over any other witness based on his experience in law enforcement. Now we only have 1 versus 10, but those seem to be far more prejudicial than I wore a medical boot.
Let me kind of push on that a little bit, because I know what Dorr says, which we shouldn't speculate, but what kind of evidence would we ever find that a juror was actually tainted and actually made it on the panel? Because it seems like by definition, if you have a juror that says, ooh, I heard what the other juror said, and he looks like a respectable guy sitting next to me, so I'm going to buy that. He's not making it on the panel. So how would we ever, under Dorr's standard, find a jury to be tainted? If not 10 guys kind of all going, we think he's guilty because he wore a boot, what is the threshold that we would reach?
I think actually Mock is a good example of where the trial court didn't take sufficient inquiry to determine whether comments tainted the entire panel. So there, a person that worked with minor sexual assault victims stated on 4 separate occasions that she had never known one of these victims to lie about these allegations. They had always borne out to be true. And she had worked with psychologists and psychiatrists in the area. The trial court then asked if any other juror disagreed with her statements, and no one raised their card. So there, the trial court didn't take sufficient steps to ensure that these comments didn't have a prejudicial effect. So
what are the examples here in our record of where the trial court addressed the Mock problem?
After the discussion, immediately explaining the burden of proof and the presumption of innocence, and the seated jurors didn't have any issue with those instructions, and also that they could decide the case based on the evidence presented at trial and basically disregard those other prospective jurors' comments on medical boots.
So when a DUI issue arises and you ask people in the panel, is there anyone here who's had an experience X involving a DUI? Typically, to my experience, the last question the judge asks those people is, would your experience prevent you from being fair and impartial in this case if you were directed in a certain way by this court? And if they say, yes, that would be a problem for me, then you say, okay, you're gone. If they say, no, I can still be fair and impartial, did the judge make any effort to determine whether or not the people in this case attested to being able to still be fair and impartial?
Yes, there were, out of the jurors that said they had worn a medical boot or whether they had received advice about driving with a medical boot, the trial court specifically asked those if they could set their experiences aside. Some of them couldn't, and they didn't make it onto the panel. And I think the appellant mentioned that Juror 51 did make it on the panel, but Juror 51 did not have any experience with a medical boot or receiving advice about wearing a medical boot while driving. Juror 51 initially raised his or her card when the trial court explained the burden of proof, presumption of innocence, and asked if anyone sitting here right now believed the defendant was guilty. I believe Juror 51 initially raised his card based on that question, but after further instructions, said he could be fair and impartial. So it was a misunderstanding of the trial court's initial instructions. And the defense did not move to strike him for cause or use a peremptory strike on Juror 51. And if anything, the discussion about medical boots would help the defendant to select a jury that would, he believed, more beneficial to him, because he would want to remove people that have received some sort of advice about driving or even just have a common experience of wearing a medical boot and what that feels like while driving. So here we just
Did the
don't.
defendant ask at any point to take individual jurors into the court's office and discuss the issues where the rest of the panel would not be present?
No, there wasn't any request for a individual voir dire. There was an off-the-record discussion after two of the prospective jurors had raised that they had worn medical boots. We don't know what happened, but then they continued with voir dire in front of the entire panel.
So the concern in the course of this process, in the heat of the moment, if you will, the concern was not, let's get this person isolated and see how much damage they stand to give us, cause us. It was just, let's go on with the process.
Right, there wasn't any indication that there was a concern that there was some pervasive prejudicial effect of the prospective jurors' comments.
Thank you.
If there are no further questions, the state asks that you affirm Kitko's convictions. Thank you.
Thank you.
Procedural rules give effect to constitutional rights. Mr. Kitko has a constitutional right to a fair process during jury selection. So I also want to point out whether or not this court sees it as a constitutional issue, a statutory issue, or a procedural issue under Rule 18 as the prosecution views it, the court would still review this de novo. And I do want to point out, Your Honor, that in regards to the issue you raised about the number of people who are familiar with DUI cases, it's not just one or two. It's the number of people on the panel who would feel free to opine about the evils of drinking and driving. So whenever you get to that tipping point, which we got to here, it would have been appropriate to either do an individual voir dire or to dismiss this panel and get another one.
But counsel, it only takes one juror to hang a jury, right? So you got to get all those people that may have been tainted by the comment made by another juror, right?
Well, it's interesting that you raised that, because I was going to get to this point. We are in the era of the Colorado method, which tells you that cases are won or lost during jury selection. And when you instruct a jury according to the Colorado method, the jurors are instructed that they cannot be tipped by one person or the other. They have to hold on to their own sense of what's at stake. This jury pool was not instructed along those lines. So I don't believe that we can say, hey, it only takes one juror to basically tip this case one way or another. This jury was not instructed that they could have that right. I'm sorry, I see my time is up.
Thank you, counsel.
Thank you.
Thank you.
This is one of those quandary issues for me. I think it always has been. I appreciate the argument today. Thank you very much for it. We're going to take the matter under advisement at this time, and we'll rule in due course. Thank you.